Hi guys, this is Ayantika, your legal faculty here at CLATapult, and in today's video, we are going to discuss the Industrial Relation Code Amendment Bill of 2026. The Industrial Relations Code Amendment Bill of 2026 was both passed by the Lok Sabha and Rajya Sabha, and this is an important update in India's labor law framework. So what is this exactly about? To understand it, we need a little background. In 2020, the Parliament passed the Industrial Relation Code as part of the larger labor law reform process. The idea was to consolidate old labor laws into one streamlined code. The Industrial Relation Code deals with trade union industrial disputes, strikes and lockouts, layoffs, retrenchment, and closure of establishments. It replaced three major pre-independence and post-independence acts: the Trade Union Act of 1926, the Industrial Employment Standing Order Act of 1946, and Industrial Dispute Act of 1947. Now here's where the issue began. Although the 2020 code stated that these three laws would be repealed, there was legal ambiguity about how exactly that repeal took effect. Some interpretations suggested that the repeal would depend on a formal government notification bringing the code into force. Others argued that repeal happened automatically by operation of law once the code became applicable. This confusion could potentially create serious legal challenges. Imagine a dispute in court where one side argues that the old Industrial Dispute Act still applies because the repeal was not properly notified. That kind of uncertainty can create inconsistent judgment and prolonged litigation. The amendment bill passed addresses this issue. It clearly states that repeal of the three acts took place by operation of law and not merely through any executive notification. In simple terms, Parliament is clarifying that once the Industrial Relation Code came into effect, those three acts automatically got repealed. The amendment also gave a clarity regarding the effective date from which this repeal was considered valid. By doing so, it attempts to close the door on any future argument that the earlier laws continue to survive in certain situations. Now, coming to the government's reasoning. According to the government, this amendment ensures certainty. This prevents confusion among employers, workers, tribunals, and courts. It strengthens the structural foundation of the labor code regime and avoids unnecessary litigation. But there is political and ideological debate as well. Several opposition leaders and trade unions argue that the broader labor codes already tilt the balance in favor of the employers by increasing flexibility in hiring and firing, raising threshold for prior government approval in retrenchment, and imposing stricter condition for strikes. From that perspective, even a clarificatory amendment is seen as a part of a larger pro-business shift. There are also concerns about retrospective clarification and whether it affects the pending disputes or workers' rights that arose under the old laws. So what does this mean overall? That this amendment does not introduce new worker benefit or new employer obligation. Instead, it strengthens the legal architecture of the Industrial Relation Code by removing ambiguity about status of earlier labor laws. This is a technical amendment, but technical changes in labor law can have long-term implication for industrial relation, dispute resolution, and judicial interpretation. In short, Parliament has chosen clarity and consolidation over interpretive uncertainty. The real impact will be seen on how the courts apply this clarification in ongoing future labor law disputes. Thank you and see you in the next video.